Hi, welcome to another episode of Bridging the Badge. I'm Officer Paulos, currently assigned to Community Outreach Unit. Today on this episode of Bridging the Badge, we are going to explore the meaning of constitutional policing, why it's essential for both officer safety and public trust, and how having a police legal advisor can guide departments in aligning their policies and practices with the Constitution. So on that topic, with me today, our special guest is Mr. Erik Scramlin.
Thanks for having me. Appreciate it. Of course, you're paying me to be here, so I might as well make the most out of it.
Exactly. So, Erik, tell us a little something about you.
All right, so name's Erik Scramlin. I am from Michigan originally, so if you know me, you know that I am obsessed with the Detroit Lions. So it's been a rough couple of years, but pretty confident that as we say every year in Michigan, this is the year. So I've been in New Mexico for several years now. I started off as a prosecutor in Hobbs. Just moved to Las Cruces about a year ago and enjoy it quite a bit. I practiced criminal law pretty much my entire career. And now with you guys, I am an advisor.
Yes, and we greatly appreciate it because I know myself, my partner, are giving you several calls in regards to some of the calls we're working.
Yes, kind of reconsidering the on-call portion of the contract.
We're going to have to discuss that with Chief later. So, Erik, what is constitutional policing?
So, great question. And there's several trains of thought on this. To me, if you put it the most simply, it just means policing within the bounds of the law. You're staying within the parameters of the Constitution. You're using it as the guide that we're not going to go outside of this in our policing. But I think it's much more than that. It takes into account not just, one of the questions I used to get asked years ago as a prosecutor that now I realize was a terrible question was, hey, this new case law came out. So what do we need to know about it? How do we get around this? And what you realize is that's absolutely not the way to look at it. Instead, you look at the new case law and you say, I'm going to know everything there is to know about this. And I'm going to know it better than the attorneys. And then we're going to apply that to training. And we're going to apply it as part of our job. So to me, constitutional policing as a whole, it's not just staying within the bounds of the law, but it's about having the relationship with the community. So you're not just doing it because the law says you can, but you've incorporated it in a way that you're actually enforcing the law, helping the citizens, and you're not violating their rights. So that's kind of the big version of it.
Well, you answered my question, which was why is constitutional policing a good policing practice? So thank you for answering that. So my next question would be, what is a police legal advisor and why is that important?
Yes. So I've been, it's kind of a journey on how I got here. And you probably don't, when you look at attorneys, you don't see a lot of police legal advisors out there, but it is kind of a niche field. And it's an attorney that works specifically with the police department. So for example, at one point in my career, I worked at the city attorney's office. And that's kind of like, you can think of your city attorney. It's a tough job because it's like being a general practicing attorney for a large corporation. You have to handle, in the morning, I might have to review a contract. And we got to go to a meeting. Then we got to make sure HIPAA is followed and we're not violating the Open Meetings Act. It's all kinds of stuff. As part of those duties, you have a police department. So the problem with that is the city attorney is so busy that a police legal advisor kind of fills in the gap. It's all we do is advise the police department on the law. So I kind of say it's sort of like movie 300, where he asks, "What is your profession?" Everyone's like, "Yeah, I'm a carpenter and I do all this." Spartans, what's your profession? That's all I do. So the benefit for the police department is that I don't have, a bunch of other things taking up my time, and that the training that we put together is going to be top notch. And then I can address the concerns as they come up.
Well, I definitely vouch on that training. I know every time we get our mandated training and I see your name on it, I'm like, okay, this is going to be a good one. So
I try.
Take that how you want to take it.
I try.
So my next question for you, and as much as I don't want to ask this, I feel like the public should know. So what is a common mistake you see repeatedly in policing?
Yes. So to answer this question, let me give you a little bit more of my background. So I spent most of my career as a prosecutor. It wasn't until I went to the city attorney's office and I saw the civil side of policing. Because as a prosecutor, you got a busy job, you get the case, you prosecute it in court, but you're not concerned, you're not fighting lawsuits, it's just criminal law. So it was that time as a city attorney that I realized in every single one of the lawsuits that were filed against the police department, I noticed a pattern. And that pattern was that the officers did not know the law. They felt like they were doing the right thing. They'll respond to a domestic violence call and order someone to come outside, but they don't. They go to slam the door in their face. They're thinking, well, someone might be injured. I got to make sure I get in there. They put their foot in the door. In their mind, they think they're doing the right thing in their heart, but they don't know the law. And what I found was when I looked into it is that New Mexico is, and not just New Mexico, I mean, this is nationwide. We don't spend enough time in policing focusing on what's really important. And that is, are we emphasizing the law? Does that officer recognize when he puts his foot in the door what the Fourth Amendment is, how it protects that individual? If the officer does recognize that, I always tell you guys, you gotta plan for what's difficult while it's easy, and every battle's won before it's fought. We go with the old art of war quotes. If an officer knows the law, they respond, they're asking the right questions, they're getting clarification from dispatch. By the time the door is slammed in their face, they already know whether or not they have legal justification. Emergency scene doctrine applies because I've articulated an emergency, hang-ups on 911. They recognize that, they go in, and now lawfully they can do it rather than just, well, I thought I was doing the right thing. So getting back to the question, what is the most common mistake? I work with a lot of departments across the state. And the biggest thing I see right now is it's 2025, and there's still with some agencies a failure to recognize how important legal training is. When we see major lawsuits, or God forbid, sometimes when officers get prosecuted, and you talk to the U.S. attorneys who prosecute those cases in federal court or in the civil rights cases, you find out that there was woefully lacking in training, and not just traditional law enforcement training like you guys always do, where let's go to Santa Fe and listen to some guy read a big long PowerPoint.
Oh, God.
But we're not focusing in on the important aspects of the law. So I see a lot of agencies that are kind of stuck in a mindset that was 20 years ago, where they'll just use their local DA, come in and do the mandatory minimum requirement, which is shockingly 2 hours of legal update. It's all that you guys are required to get every 2 years. And just recently, they've added use of force to that. So it's 4 hours, but 2 hours and 4 hours a year for training on that important of a topic is not good enough. So the biggest mistake is they're not realizing. A lot of agencies like ours is now, but the biggest mistake is not realizing that this is so important to do the training. It also keeps me in business, so I gotta talk about that.
Yeah, you got to pay the bills somehow, right? Well, I guess it answers that question of how exactly we're being sued, and it just goes back to us not us, I should say, but in general,
Yeah,
people not understanding the law 100%.
yeah, and I give you some specific examples. What are the common lawsuits we see? So by far the most common ones are search and seizure violations, where just that, you respond to a domestic and you don't understand what the law is, so the foot goes in the door. Now we're in someone's house and Fourth Amendment applies. Do we understand this? So we see a lot of those. Reasonable suspicion to detain. What's the training we just did recently? Something that's been a common practice for years, where you go to Walmart or some store and they're like, hey, we want that guy criminally trespassed. So for those of you that don't know what that is, if someone's at a store or a place that's like open to the public and it's not posted as no trespassing, the owner of that place can say for whatever reason, we don't want you here. Then if they return or come back, it's trespassing. So a lot of times these guys get called to issue a criminal trespass warning. And that's just, here's a note, says that you can't be here, signed owner or manager of store or property. So what we talked about recently is, can you detain someone just because they want to issue that criminal trespass warning? You're paying attention.
I was.
All right, great. Yes, absolutely. So it was something that was a common kind of area that even for me, I kind of forgot about it. The case came out, I looked at it and I said, we should probably cover this in a training. So we see those. It's, we think of like these big events that cause lawsuits. They do. Like you can get really bad lawsuits from officer involved shootings and things like that. But oftentimes it's the little stuff. It's, hey, I need to see your ID. And do you have reasonable suspicion to demand that ID? And then it escalates and we don't de-escalate it. And there's a use of force. So search and seizure, excessive use of force claims by far the most common. Those are the ones that I think we spend a lot of time working on.
Yes, I'm glad you kind of, I guess, explain that whole process as far as trespassing, because I know I see a lot of things on social media in regards to that. It's like, well, this guy's here, I don't want him here. But a lot of the times people will call in anonymous, and that doesn't really help us that much. Like, how am I supposed to trespass somebody from a business when you call it anonymous? So, and that's where it kind of gets a little hairy. That's where us as officers have to do a little investigation. Like, okay, you're the manager, it's your property. Do you want us to trespass this bill subject? And is he still on the property?
Yeah. And then the challenge would be if, hey, did you tell him he's not supposed to be there? Well, no, he's scaring customers. I don't want him there. So then now you can't detain him because he hasn't committed a crime. So it's just a consensual encounter. So it makes it tougher occasionally.
Hence why it's important for a lot of the businesses to understand that too. It's like, you guys got to take that first step. I'm not saying put yourself in danger, but at the same time, you have to let them know they're not wanted there. And that's what we come in.
Yeah. Yeah, that's great.
So public opinion versus courts. Can you elaborate a little on that?
Yeah. So this is one we talk about quite a bit because my job is to make sure that you guys know and understand the law. We look at something like use of force, which is really massively important to the community, to you guys, because it's this balancing act. On one side, you guys are out there. Your interest in being safe is something the government wants to protect. But at the same time, we have the Fourth Amendment rights of the individuals out there that we don't want to violate. So it's this constant kind of balancing test. And my job is to make sure that you guys understand the law, because oftentimes the law and what, the court of public opinion will say maybe two different things. So that can lead to bad outcomes in both, aspects of you hesitate to make a decision and then something very bad happens and it's not safe. At the same time, also, if you take that into consideration, then you may cause you to do something that you probably shouldn't have that's outside of the bounds of the law. So what we try to focus on is, again, what I said earlier with the constitutional policing. I make sure that you guys know the law better than the attorneys do. I'm trying to. You're doing pretty good. Got a little bit of work to do here, but for the most part, we're doing good. So in doing that, the goal is that they know the law as well as an attorney does. And in doing that, you help keep the public perception of, hey, we got officers that are doing the right thing. I mean, we're number one in crime. New Mexico is number one in crime. I think the public wants you to enforce the law, but at the same time, we don't want a police department that's enforcing the law in a way that's violating people's rights. And it can be done. I mean, that was, as a prosecutor, I had an ethical duty. If I got a case where someone's guilty, but their rights are trampled on, I can't go forward with that. So I've been doing this for years and working with law enforcement, even as a prosecutor, saying, hey, we want to get a conviction. This is a bad guy. So let's do it right. So hopefully that kind of answers the question. We want to do it in a way that, the community's proud of you guys. But at the same time, you have to understand what the law is.
That's very true. So I think you kind of touched on it, but why is it important for police to proactively train rather than react?
Yes, well, that's a good one. And that's something that we've been doing for a while. So you guys I can tell you're still a little angry about the test.
I thought I did pretty good. C's getting degrees.
Yeah. So one of the things that we did in being proactive, because I've done so much search and seizure and use of force training, that we actually I had you guys take a test, and I drafted the test to be similar to what you would see on the bar exam. So initially the response was like, oh my God, why are you doing this to us? But at the end of the day, once we went through it and we identified the mistakes and we went through remedials, now everyone in the department has passed the test. So why is it important to be proactive? Because as we talk about all the time, you can't wait until the lawsuit is there. That's too late. And by the way, that's why I do this. The goal is we want to prevent these lawsuits from happening. It's not good for the community. It's not good for the department. The taxpayers are paying the bill on this stuff, so they're not good. So the goal isn't, in my old job as the attorney, I'm going to come in and represent you and we'll try to win the case in court. We want to keep it out of court. We want the lawsuit to never be filed because we're doing things the right way. That's where the proactive comes in, is even though that time is precious and we do a ton of training, you guys get angry at me sometimes. I know you do. It's okay. I've seen the memes out there.
I'm not gonna lie. You saw those.
Yeah, well, saw a couple. Yeah, Chat GPT. It makes some good memes these days. But the reason that we do that is because we have to. It's easy to do it now, to get in the classroom and then get out and do reality-based scenarios. We're doing it so the lawsuit never happens. Once the lawsuit's filed, it's too late. The damage has been done. Even if we ultimately win it, the damage is still done a lot of times by just being filed. And then I've seen what you guys go through, and it's terrible. It's not fun. fun experience.
So speaking on our proactive training that we receive, what are the big topics you think we train on?
Yes. So the biggest topics that we train on are obviously things that we do a lot, search and seizure. I mean, this is everyday work for a police officer because, again, you guys are paid by the taxpayers to go catch bad guys. But at the same time, you can't violate people's rights. So we hammer search and seizure, right? We talk about understanding, do you have reasonable suspicion to stop this person? And if you don't, you recognize that you don't have it, you don't make the stop, or you do a consensual encounter or something like that. We have, these operations that come up where we can't just go out and detain people. You can't go out and just demand someone's ID. This isn't, it's not Russia. So you got to have, you have to have reasonable suspicion to do these things. So we focus on that. What would give you reasonable suspicion? And recognizing when you don't have it is almost as important as recognizing when you do. So you can lawfully make the stops. And then if you got nothing, you let them go. Even if you got that gut feeling that there's something going on, if you don't have the facts to support it, that you try to come at it a different way. What else do? We do a lot of use of force law stuff. So I think I've been very impressed with how you guys have been handling that in the classroom, because that is a legally heavy topic, even for attorneys to discuss, the ins and outs of Graham versus Connor. So, and then you guys have to make those split-second decisions. You don't have time. That's why I said I'd be a terrible police officer. Because I'd be out there with you guys and, some guy with a gun, I'd be like, hang on a second, sir. We're going to look up this case real quick. All right, what does he got, a gun? What kind of gun is that? All right, are you pointing that at us right now? Okay, yeah. Okay, Tennessee v. Gardner, I think we're good. I wouldn't be able to do it. These are split-second decisions that sometimes happen in the blink of an eye. So it's repetition. We do it over and over and over again.
Yeah, the way I always viewed it is just kind of like when you go to the range and we're, getting proficient with our firearms, it's the same thing. One proficient with the laws and the ever-changing laws. And I think that's one thing that I appreciate is like whenever that new law comes out or some kind of bill is passed, you're quick to jump on it and you're quick to put together a training.
Yes. Yeah, and I'm glad you brought that up. That makes me think of another topic. I probably should have answered this when you asked about what's kind of the bigger picture problems out there. I think, let's see how we frame it. New Mexico has done a lot to get legal training into our curriculum. So we've seen changes like adding excessive use of force, but I still think I think there has to be a shift in law enforcement. Like, for example, I was teaching with the cadets today and they spend how many hours on firearms and how to load them and tactics?
Long. I would say, if I recall in my academy, it was like a week, 2 weeks.
Yeah.
Intense. Yeah.
And then how long do we spend on search and seizure?
4-hour blocks sometimes.
4-hour blocks sometimes. When I've taught at the academy, I've extended it sometimes to 8 hours. Do we really expect that we're going to take a 22, 23-year-old kid who doesn't even have a whole lot of life experience, and in 8 hours, we're going to teach him what I learned in 3 years and then 10 years as a prosecutor on complex areas of constitutional law? There needs to be a shift from, we need to stop working so much on this and maybe start to emphasize more training on the legal aspect.
Yeah, I agree.
Do we get any questions?
Yes, for those who are watching live, if you have any kind of questions, please post it on your Facebook. Actually, we do have one. So one of the questions came from our social media is, anything the community can do to assist with crime reduction from a legal standpoint?
Yes. So I assume this is like local businesses, just general members of the community. Yeah, absolutely. So first of all, you have to have a realistic idea and take time to look it up. I know when crime is as high as it is right now, everyone blames you guys. They blame the DAs. They blame the mayor. It's all their fault. But have you looked at the courts? Make sure that you take time to educate yourself on how a case is prosecuted. How does it go through the system? What are the due process rights that apply? When you recognize that, you realize that you can't just call these guys and be like, there's a guy being suspicious. Are you going to make a stop on a suspicious guy? No. We've talked about that one many times. Mm-hmm. So you can't, just because they look suspicious, they have to have reasonable suspicion they're committing a crime. So you need details. What is the person doing? That's what I've always told you guys. If you're going to make that stop, I want to know the facts. What are they doing that looks suspicious? And is that reasonable suspicion they're involved in a crime? So the details matter. The other thing that was incredibly frustrating for me as a prosecutor is when the crime's reported, it's called in, give a statement, and then now it's time to go to trial a year later. No interest, don't want to go. It doesn't matter if they make the arrest. There has to be the follow through, and we have to be able to take it to court and get a victory. And you would be astonished at the amount of cases that are dismissed because we just can't get witnesses to come to court. So I'd say the big thing is details, because you guys can't just go and stop someone. So you have to have reasonable suspicion. And then just kind of recognizing how the court system works. And it sucks. I know, no one wants to go to court. I mean, that's why I'm doing this. I don't want to go to court anymore. So it's hard, but if, ultimately, if we're going to make a difference, it's not just arrest someone. We can't arrest our way out of the #1 in crime problem. It's going to take a lot of changes. And I think part of that is got to have some meaningful prosecutions and stick with them.
I definitely agree with that. And I'm glad that you brought that up, because I that's one of the things as a police officer, when you read all these stuff on social media, it's kind of, it's kind of discouraging sometimes. Like, well, they don't do this, they don't do that. Why are they here? It's like, man, I wish we could be everywhere, but unfortunately, there's few and far. So,
yes, exactly.
The other question I have for you, Eric, is what are risks, or what are the risks to police departments that the whole wing it, or that's the way it's always been done attitude?
Yes. Yeah, my favorite, and by favorite, I mean least favorite, I hate it. It's something I've heard my entire career. When I bring something up, like, hey, got a new case that just came out. Well, that's not the way that we've always done it. Or I'd ask, why are we doing this or this or this? Well, that's the way we've always done it. Well, if you've been doing it the same way for that long, it's probably wrong. So obviously, I think the dangers of doing that is if a department is not focused and not taking legal training seriously, we see it all over the place. You're opening your agency up for lawsuits. What that means is distrust with the community, heavy financial damage, or now instead of spending money on things that we need and important resources, we have to pay off these incredibly expensive lawsuits. The taxpayers are fitting the bill for it. And eventually DOJ could come in and take over your department if it gets bad enough. And unfortunately, I do see that attitude with some other agencies where they're just having a hard time adjusting to the fact that, like, it's 2025. It's not an option. If you don't want to know the law as well as an attorney, as a police officer, then this is the wrong career for you. That's a question I used to get, or kind of a complaint quite often in training, was like, Eric, damn it, I didn't go to law school like you did. I don't want to do this. I didn't go to law school. I'm a police officer. And my response to that now is, well, then you should retire, because in this day and age, you have to know the law as well as an attorney. And it's not, just because someone went to law school doesn't make them like a master at the law. Really, law school is just designed to stress you out for 3 years as much as possible. And if you can make it through it, then you'll be able to withstand the rigors of the law. It's just taking time to educate yourself. And I think that's the biggest problem, because if a department is not doing it, sure, things might go good for a year. It's kind of like it went good all these times. The 1,000th time we did it, massive disaster. And I've seen it in agencies I've worked with, where one incident can be years of destruction with the community. Certain areas of town where they couldn't go for years. And that's areas of town where they need the police the most, from one incident that could be prevented by not having that attitude.
And I know, speaking, both my parents are retired police officers from this department, and they tell me, like, I don't think I could be a police officer now at the time that you are. So
yeah.
And I kind of look at them like, what do you mean? It's like, there's just so much going on there. So it's not back then where it was, plain cut and dry. There's a lot more to it.
Well, I even look back when I started off as a prosecutor in 2010, and I look back at the way that policing was done then compared to now is night and day difference. I mean, that back in 2010, the legal training was me doing a training at the sheriff's department or at the PD for 2 hours once every 2 years on legal update. That's it. Here's 2 hours of training. Good luck. And of course, I got 500 cases to prosecute. So who knows how well, how much time do I have to dedicate to it? Which is again why you need a police legal advisor, because that's all they do.
And I know something that I always take from it. You kind of emphasize it a lot, and when we go through your classes, it's always the whole, correct me if I'm saying this right, the interstitial approach.
Yes. Good job. Nice.
Interstitial approach. So that's one thing I always go through my mind when I'm dealing with people. I'm like, okay, do I have probable cause to talk to this person? Like, what am I doing?
Yeah.
What would Erik Scramlin do? I always remember that.
Well, don't do what I would do because it would just be hesitating.
Well, not so much hesitate, but the Scramlin approach.
I like it. Yeah, I'm glad you brought that up. I didn't mention the interstitial approach. That's definitely so. If those of you who are unaware, New Mexico is kind of unique in its approach to criminal justice. In the 1990s, the New Mexico Supreme Court adopted this approach. It's not used by many states, but New Mexico did adopt it. It's called the interstitial approach, which I've absolutely hammered with you guys. And all that means is most states, every state's got a constitution. Most states will just kind of say whatever the U.S. Supreme Court says about the Fourth Amendment, well, that's going to be the same thing for our Fourth Amendment. But New Mexico is unique in that in the court they reasoned that New Mexico is a very unique state. We're the home of Billy the Kid, got large, wide open areas. So they felt like historically there's much more freedoms that you have in a place like New Mexico. So as citizens, we love it. It's fantastic. I love the fact that I live in a state where we have more protections than the federal government gives. But the other side of that, it makes policing very difficult sometimes because not only do you have to know that federal Fourth Amendment standard, Fifth Amendment, but under New Mexico law, the courts have said essentially interstitial approach means we're going to give way more rights under the state constitution than the feds do. So because of that, that means that you guys can't go to a training in Texas or California because you're going to learn a Fourth Amendment standard because that applies mostly across the country, drastically different here. So we spend a lot of time focusing on those differences and we strive to follow that New Mexico law. Because if you're following New Mexico law, then you're no issues with federal law, right?
Sure. I'm glad you brought that up because I feel like that's something like the general public should know. Like if they didn't know already.
Right. A lot of people don't. They kind of wonder why sometimes it seems like our courts can be lenient, but they don't understand why. Well, I mean, part of it is the courts don't have the option because if with the interstitial approach with greater rights and protections, that's much more onus on you guys. If you screw it up, then it's going to get dismissed or it's going to get suppressed, and now we lose our case.
So we have another question from our Lucas Facebook Live. So, has the threshold for reasonable suspicion become broader for a law enforcement officer now?
No. So this is interesting. We just talked about this in a recent training. Even though reasonable suspicion has been around since Terry v. Ohio, that's where it comes from, the courts have struggled. And even at times, the U.S. Supreme Court has said, you know what? We can't give you an exact definition. I'm sorry. Because reasonable suspicion it's kind of this gray area where the courts are saying what we want is articulable facts that criminal activity is afoot. So really what we do, it hasn't changed much over the years other than case law that gives context to it. And that's one area of New Mexico law where it's not really much different than the federal standard. Reasonable suspicion is reasonable suspicion. But for you guys, there is no bright line, like if they do this, that's reasonable suspicion. So what I focused on you is what you guys, not you in particular, but maybe I probably should, but is I've kind of come up with an algorithm that in all the cases I dealt with, I primarily prosecuted drug offenses that's where you see most of your suppression issues. So reasonable suspicion was common. I noticed a pattern with the case law, and that was if the officer can articulate the specific crime that he believes this person is engaged in. Is this an auto burglary? Is this person about to rob that store? By doing that, the second step in that analysis is what facts do I have to support it? And that's where the magic is for reasonable suspicion is, do you have facts to show that, yes, a crime is either in the process of being committed, about to be committed, has already been committed, or is it just a gut feeling and a hunch? If it's just that gut feeling and you don't have the facts, you don't have reasonable suspicion. So the standard hasn't changed much over the years, but the courts they've kind of give us context. And what I see from the courts is they want facts, not conclusions. We talk about that all the time. That's why we don't stop a suspicious person. We stop someone that you have facts that you can articulate that they're engaged in crime. It's not a really high standard, but you do have to have facts to support it.
I agree. Thank you for elaborating on that. I have one more question. How do officers negotiate their understanding of constitutional policing when working with other agencies?
So how?
So I'm going to assume that's working with a federal partner.
Yes, that's a significant challenge for us because we do a lot of work with with our federal partners here because of the presence. So that can be difficult. because the federal officers generally don't know and they do not understand these far greater protections under New Mexico law. So, for example, let's say that we're doing an operation with our federal partners and they've been watching a target in a car, let's say for drug trafficking. So they have us help them with making a stop. So first of all, what do you need to know before you can actually stop that car? You need to know,
why am I stopping this?
you need to know what your reasonable suspicion is. Oftentimes, sometimes they don't want to share that, but we need to know at least the minimum, like, okay, we have reasonable suspicion. So then we stop it. If they take over, they're under a federal standard. So they have what's known as the Carroll Doctrine. It's been the law since the 1920s, over 100 years. And it's where the United States Supreme Court said you have a lesser reasonable expectation of privacy in a vehicle for a number of reasons. And because of that, all you need is probable cause. Like if you got probable cause that there's evidence of crime in the car, you can search it. You don't need a warrant. It's called the automobile exception. Well, New Mexico soundly rejects that. That doesn't fit the interstitial approach. You guys have to have a full-blown search warrant or the same exceptions that apply to a home. So oftentimes a federal agent will go Carroll Doctrine in the car, find a little bit of drugs, be like, this isn't really enough for our standards. You guys take the case. And of course we can't because they use the Carroll Doctrine to search the car and it would not be admissible in state court. So when these guys become more educated and they explain to the federal officers, hey, if we're going to work together, these are the things that we're limited to. Because another thing that they like to do in drug cases is they want you to go like, we're pretty sure that that guy's got dope, but we don't quite have enough reasonable suspicion. Go follow him and wait for him to like run a stop sign or something. Yes, pretextual stops, which the Fourth Amendment, the United States Supreme Court in the Wren decision didn't say like, it's cool, go do pretextual stops, but they did say, we're not going to go there. If you got reasonable suspicion based on a crime, i.e. run a stop sign, that's all we need to know. We don't need to know what your subjective mindset is. New Mexico strongly rejects that. It is flat out banned under the New Mexico Constitution. So when you guys make a stop, you can't say, well, I think there's drugs. Let's go follow him and wait for him to commit a violation. You got to have reasonable suspicion for the drugs or you cannot make the stop. So that's another kind of problem that we have with the federal agencies. And generally they don't understand. So I think when the officer is well educated and they can have that conversation, we've done that, and that seems to help quite a bit. Because we want to work with our federal partners because oftentimes the crimes can be more serious. There's significantly more penalties sometimes in federal court. So if we got a real bad guy, we want to get him to federal court. Actually, we want to work with them.
Well, thank you for answering that question. So thank you for joining us today. Eric, thanks for being here. I was a big fan.
How much time did I get? How much am I billing you guys for?
We'll tab that up. So I just want to, for a reminder for everybody that Mock on the Block is going to be Tuesday, May 27th from 1700 to 2000 at Sam's Club off Tal Shore. So come on and stop by, speak with one of your community outreach officers or community advocates. We'll be out there sharing information and share your concerns with us as well. And also don't forget that our fishing with our cop at Young Park is going to take place June 7th. So I hope to see you all there. Thank you.
The Las Cruces Police Department would like to thank you for tuning in, and we hope to see you during our next episode of Bridging the Badge. For any questions or additional information, please contact our Community Outreach Unit at communityoutreach@lascruces.gov.